for a hearing in the matter of CFI-110-2021 before Registrar Nour Hineidi. The claimant is represented by Ashurst. Lead counsel is Bill Smith. The defendant is represented by Hadif and Partners. Lead counsel is Mr. Matthew Page.
Good morning, everyone.
Good morning.
Good morning, Registrar.
Good morning. Do we have Mr. Smith for the claimant and Mr. Page for the defendant?
This is Mr. Smith for the claimant.
And this is Mr. Page for the defendant.
Great. Thank you very much. Thank you very much for sending through your skeletons. They were very helpful. I'm not quite sure why the registry directed a hearing for this particular case, given that it's pretty clear cut to me that, and I'll give you my thoughts, Mr. Smith, and then I'll hear oral submissions on the same. But at the moment, my clear thinking is that this ought to proceed as a Part 7 claim for several reasons. First of all, the defendant says in its acknowledgement of service, and this was the main test for the purposes of my exercise. Sorry, just bear with me for 1 second while I just prepare my notes. I don't know where they've gone. So the defendant says in the acknowledgement that it intends to defend all of the claimant's claim, which means that there is essentially a substantial dispute of fact. There's many other things which also give rise and point towards characteristics of a classic Part 7 claim. First of all, the forms that have been submitted so far in the case take on the forms for a Part 7 claim. The first being the particulars of claim have been filed in the case and not evidence in support of the Part 8 claim, which is what a Part 8 form really ought to follow. Then we've got a defence, which I actually can't see on the CMS, so I'll ask Mr. Page about that in a second. But then we've got the reply to defence. Most importantly, we have a counterclaim. And the second a counterclaim gets filed, even if you have a classic Part 8 claim filed by the claimant, the fact that a counterclaim has been filed will then mean that a Part 7 claim is immediately triggered. And that's because you can't encourage a Part 8 claim and a Part 7 claim together. It makes things a lot more messy. I understand that the claimant might have reservations about why this ought to continue as a Part 8 and not a Part 7. And my understanding is perhaps it could be on the basis of truncated deadlines and obviously the calling of witnesses, etc. And even though the claimant initially thought that when it filed the claim that based on several correspondences that went back and forth with the claimant, that the case initially did not have a substantial dispute of fact, it is that entire situation can change based on how the defendant filed acknowledgement of service. And they said quite clearly, like I said, that they intend on defending all of the claims that have been put forward by the claimant. So I'll hear oral submissions on in case I can be swayed, but I'll point counsel to IDC 21.7, which is kind of the main argument that might be run by Mr. Page for the defendant. 21.7 says that where, and I'll just myself so I can read it out to you. So it says that the defendant may make a counterclaim against the claimant by filing particulars of counterclaim. And again, this takes the form of a classic Part 7. There are also many other remarks that you could probably lean on within the IDC that would give rise to a Part 7 claim. But like I said, we'll hear from counsel first, and then I will make a conclusive decision on the same. Thank you. Mr. Smith.
Thank you. Can I just probably start with where you left off, Registrar, on Rule 21.7, which is the defendant may make a counterclaim by filing particulars of the counterclaim. Our submission is that they haven't made a counterclaim at all, because, and I hope our rules are the correct ones that are in date, but Rule 837 provides where a Part 8 procedure is used, that Part 21, counterclaims and other additional claims, applies, except that a party may not make an additional claim as defined by Rule 21.2, which for relevant purposes here includes a counterclaim, without the court's permission. And our application or our submission is a simple one on this point, which is they haven't sought the court's permission. Therefore, notwithstanding Rule 21.7, a counterclaim has not in fact been made. Leave hasn't been sought to make a counterclaim. Therefore, the only claimant in these proceedings is my client, the claimant, REEM Capital Construction. So we'd say that's the first point, and so that really shouldn't be something that comes into your thinking. The second point I think we'd make is that even though the respondent may have said that it intended to defend the claim, we say that actually by itself isn't relevant to the test that has to be applied here. And the test is that the claimant, which in this case can only be my client because it is the only claimant, because even though they may have referred to a counterclaim in future, we'd say there is no counterclaim at the moment because leave hasn't been sought nor granted. We'd say that our claim is unlikely to involve substantial dispute of fact. So even though they say they intend to defend that, that does not mean that there is a substantial dispute as to fact on the claim as presently stated, because there may be other reasons why they intend to defend the claim, such as on a matter of contract interpretation or some other matter of the application of UAE law. But analysing the claim itself, there are a relatively small number of facts that need to be proven, and we'd say, and this is in the submission, so I won't go into it in any detail unless you'd like me to, but the relevant facts, particularly in relation to the payment claim, are all plain from the face of the documents. The contract has been admitted. The payment clause, which forms part of the contract, must therefore be admitted. The payment claim's been admitted. The certification of the engineer is evident on the face of the document. The certification by the employer is evident on the face of the document. The due date for payment has passed. These are all things which there cannot be a substantial dispute of fact on. It's from the claimant's perspective, it's difficult to see why this would not be a classic Part 8 claim. In relation to the two documents which the claimant has belatedly wished for insertion in the contract, I think trying to perhaps underline their claim or their submission, their position. The last one of those, which is in the bundle at page 184, which is a letter that they had solicited from the engineer, actually we would say goes to support the claimant's argument here that this is absolutely ripe for Part 8, because on the previous page 183 we see the respondent writing to the engineer, asking the engineer to revise the statement of completion, which is the engineer's certificate. They've said it's not correctly valued, and the engineer has done nothing of the sort. In fact, he's done the opposite. He's actually said he's taken into consideration all of the matters which Mr. Page's client wishes to say things upon which there is a substantial dispute of fact, and they've been taken into consideration in the payment certificate, and the payment certificate is correct. Now, what we'd say is that in coming to a decision on these matters, we'd respectfully submit that in addition to the provisions of Part 8 themselves, one must look to the overriding objective as well, and in relation to dealing with cases justly. And it's the fourth limb of that, which is ensuring that cases are dealt with expeditiously and fairly, that we would say is probably the main tenet at issue in this case, because what we've got here is effectively an enforcement of a liquidated payment which is due. It's not seriously in dispute. It's actually been certified by the respondent itself. There is no, and I don't want to get into the arguments that might be available to the respondent in relation to a claim that it may wish to make in due course, but there's no way for it to challenge that certificate, and we'd say it's entirely proportionate that this matter be determined now as a separate case. If the respondent has a claim, it can make a claim under Part 7, but we'd say that as far as the claim is concerned, it's got two simple claims: one for payment of a liquidated debt which is being certified by the engineer and the claimant is due in the amount that's claimed, and B, for the return of a security check which has used its purpose because the amount has been repaid. And there's no substantial dispute, we would say, on any of the facts underlying that claim. The respondent doesn't point to any in its submissions. It merely points to what it says is a counterclaim. We say it's not a counterclaim because leave hasn't been sought, leave hasn't been granted, and if leave were sought, we would most strenuously state that the court refused that on the basis of the overriding objective, because it simply wouldn't be dealing with the claimant's claim expeditiously and fairly. And we say there's no prejudice to the defendant in any of that, because it could bring the claim that it wishes to bring at any time under Part 7 under the rules.
Thank you, Mr. Smith.
Thank you, Registrar.
One consideration actually is that this also falls, or potentially falls, Technology and Construction Division claims. I don't know if you've had to look at Part 56 of the RDC. The Technology and Construction Division claims can be Part 7 or Part 8 claims, and they would go before a specialist judge, fight these with construction. But what needs to happen, there has to be an application to transfer the case. I think my exercise for today's hearing, they proceed on high level one, can't quite go into the evidence at this very premature stage. I can't go through the evidence at the substantive hearing. So one way of perhaps moving forward with this is to seek a transfer of the case C. And the judge can then either proceed to decide in the event that, and I'm only suggesting things here, you can either proceed to Part 8 and then decide to Part 7. Now, if it is moved for Part 7 claim, then even if the essentially, if you fast forward a little bit, the respondent has sought the leave of court to make a counterclaim, but I could make an order right now that does need to do that. And if the claims are very clearly aligned, then chances are the counterclaim will be approved and the leave of court will be obtained and joining on. Now, the question at that stage is, will it be dealt with as a counterclaim, or does the defendant, I suspect, Mr. Smith, you might make say, no, it shouldn't be a counterclaim, it should be very separate. The next question after that is, should the claims be consolidated? Lots of reasons why they probably might have to be consolidated. If they involve the same parties, the same subject matter, the same contract. So even if we fast forward, we do, whether the respondent decides on bringing a counterclaim or a fresh claim, chances are that even if brings a fresh claim, it will be consolidated with this particular case. If it brings a fresh claim, then even if we go with your argument that this case is a very straightforward one, which involves a enforcement of liquidated damages payment, or rather liquidated payment, which is due, then you would still have a separate claim made by the party on the other side, being the same CFI case, and they might. Essentially, what I'm saying is they would have a very, very similar case to yours, and it would relate to the exact same issue as this case. So you might still be looking at consolidation. If they have a Part 7 case, then you can't run a Part 7 and a Part 7 separately. It would be quite messy. So you'd have to make them, or you'd have to form them for Part 7. And I know that probably at that stage, you might bring submission to the court to say they can't be consolidated because, like Part 8 means you might have very deadlines. Why do you have to wait to get a payout? That they're decided by the court, and I think that's an exercise down the track, which ought to be Technology and Construction Division. So I hope that makes sense. In case it doesn't, I can rehash my thought process at the end after Mr. Page makes his submission.
Could I just perhaps respond to that, because it will give Mr. Page the response to the opportunity to respond. And it just goes to the final part of our skeleton, which is on the directions that we have sought should the matter proceed to Part 8. And we would see that there is no reason why a determination in the claim couldn't be made very shortly after the 6th of March. And in fact, we would submit that a hearing isn't required for this matter. So in effect, and going back to the overriding objective again, this case could be disposed of well before any counterclaim may in fact be filed, but also certainly well in advance of any first directions hearing in the Technology and Construction Division, or any of the complexity of that. And we say that the simplicity of a case like this, where there isn't a substantial dispute of fact, really it is one amenable to Part 8, because otherwise it simply penalises the claimant in trying to get a quick, just and efficient or cost-efficient result. If we get put into Part 7, the standard directions wouldn't give us a result until well after the same time next year. So there's a significant delay that would be caused to the claimant's recovery. And we say that's a matter that ought to be in the court's consideration when it makes any orders.
Thanks, Mr. Smith. Just as a matter of practice, substantive hearings for Part 7 and Part 8 claims are never usually decided on the paper, even though it's an option for the RDC. But I think the real question now is whether the defendant agrees that this is a simple enforcement of a liquidated payment which is due. Because that's almost treating the case as though it's been decided. And if it's simply an enforcement kind of situation, then yes. If the defendant agrees with that, then yes, you can just simply go to a very short hearing where the court says, the defendant might say, we don't owe this amount, but we owe this amount instead. And it would provide submissions as to, no, this is the amount that's actually due to us, and the court would make a decision. But at the moment, it's almost being treated like an arbitral award that's been issued, and you're simply seeking recognition and enforcement of that. And I don't think that's quite the scenario. It's your submission that this is how this should be treated. Then very, very different views on whether this is a very simple and straightforward enforcement of a liquidated payment which is due. So, like I said, to go back to your first point that's been made, I don't think that even if this was a very, very straightforward case, it would always usually go to hearing. It could be a very short one. It can be listed as quickly as we need it to be listed. If it is indeed a very straightforward one, we can list it as early as next week if everything's already changed on the topic. But my gut tells me, based on my review of the defendant skeleton, is that they think that this is a much larger. They may have admitted certain things initially before it was filed, or before the case was filed in the DIP court. But between that, between the period of admitting certain things and the dispute being filed, it may have come to the defendant's attention that certain things were not complied with, and I can see that there's delay matters raised by the defendant as well. So they're, in my view, they're not saying that it's a straightforward enforcement of a liquidated payment which is due. But obviously, I'll let Mr. Page speak for himself. Is there any further submissions you wish to make, Mr. Smith?
I think just on the points that you raised, the analogy to enforcement of an arbitral award, we would say, is quite opposite. What you've got in this case, and I don't know if you've seen it in your bundle, but if you go to page 51, which should be document number 5, I think, or document number, page 51, that's correct.
Is that the contract?
Yeah, so what you've got here, if you flip from page 51, 52, 53, 54, 55 and 56, is a 6-page construction contract.
It's not very legible, unfortunately, so I can't quite read it, but carry on.
Well, I'm unsure about that, but I suppose the point to make, which may not require you to read the specifics of the document, is that it is a 6-page construction contract. That is it. This isn't a 1,000-page construction contract. It's actually a very short contract, and it doesn't have any of the paraphernalia that comes with the FIDIC suite of contracts that you may be used to seeing in the region. And that in itself, I think, tends to suggest that this is a much simpler claim, although admittedly that's a matter of submissions rather than a matter of fact. But the reason why I was drawing it to your attention is because in the payment regime, and there's 2 clauses, 5B and 5C, it has a dual certification. So not just certification by the engineer, but also certification by the employer. with the payment being due 45 days from the date of, we would say, the second certification. And that's why we say it's more akin to an enforcement of an arbitral award, if you like, in the same way that under construction contracts, sometimes the engineer is seen as a quasi-arbitrator. Determinations have been made. The contract requires payment once the determinations have been made. And that was done sometime, that was due sometime in September. And it's now January. And I think the only other point to make in terms of the, I suppose, the nature of what the defendant now raises is that all of the facts upon which it purports to rely in its foreshadowed counterclaim is that they were all made known to the engineer and they were known to the employer at the time. But as the engineer says in his most recent letter of December to the employer, he had no instruction to apply delay penalties. So we would say justice in this case, and the overriding objective says, let's deal with this Part 8 claim. This can be done in a couple of weeks. If the claimant's got something to bring against, if the defendant has something to bring against the claimant, let it do that. But we'd say their claim for what they say is liquidated damages, and it's unfortunate you can't see the contract because they've got a mountain of work to do because the clause is just over one line long in the contract. It's actually called liquidity damages, and there's certainly no right of set-off or any way that it shape or form that it relates to the certification provisions of the dispute that the claimant has brought. So we'd say that's an entirely different matter. It's entirely proportionate to deal with it separately. We'd also say there's no prejudice to the defendant because it's holding security, one of which we're seeking back because it's for a loan that's being repaid. But there's simply no injustice to the defendant in doing that, or no prejudice, but disproportionate and real prejudice to the claimant in not proceeding forthwith with its claim. And I think that's where I'll leave it, Registrar.
Thanks, Mr. Smith. Just a quick question. Do you have any concerns about the defendant's ability to pay if this was enforced, or whether if a decision is made, not in the next 2 weeks, to have some time down? Because if you do have those concerns, I would urge you to have a look through. And I think before your case was filed, I may have had on part.
Sorry, the lines are, sorry, this Mr. Page, the line's slightly breaking up, unfortunately.
Same for me, Mr. Page. Sorry, Registrar, we could not hear you.
Okay, I'll start again. Can you hear me now?
Yes.
Thank you. Can I ask everyone to put their phones on mute, please? Just because sometimes that interject with the connection. Thank you. So part 25 is the part that I was referring to, and asking Smith whether he had concerns about or whether his client had concerns about the defendant's ability to pay, cash flow concerns, for example. Because if there are those concerns, in the event that this case is not decided in the next couple of weeks and there's concerns about payment in the next few months, for example, essentially this case could be run as a Part 25 on no defendant, and it can be decided that way. But again, I'm just gauging, Mr. Smith, if this is something that has been considered by your client, Part 25.
It has, Registrar. I must be careful about what I say because of the conduct rules of the GIFC court in terms of communications that may or may not have passed between the parties. And as you'd be aware, in order to get interim remedies and the nature of proof that is required, it is reasonably difficult in Dubai to obtain the sort of transparency in terms of asset backing and those things that in other jurisdictions is reasonably straightforward. So all I can say is that the claimant is concerned about being able to enforce any judgment, but I cannot put it any higher than that.
Understood. Thank you very much, Mr. Smith. Mr. Page, over to you. Thank you. Mr. Page, are you there?
Hello, can you hear me? This is...
Yes, thank you, Mr. Page.
Yes, thank you.
Apologies, I think there was just a problem with the muting. Thank you, Registrar. It's absolutely right, as the Registrar has said, that this is a classic Part 7 claim. The acknowledgement of service filed by the defendant has made absolutely clear that the defendant is defending all of the claimant's claims, and it's absolutely clear from the acknowledgement of service alone that there are disputed facts. The claimant has also filed a particulars of claim evidence in support of a Part 8 claim, and that's a further reason why it should be in Part 7. And it's also absolutely clear that this is a large construction dispute over a complex project with claims and counterclaims going both ways. And it does not make any sense whatsoever in the defendant's submission to consider one issue in isolation, consider one issue divorced from the wider claims and counterclaims going both ways. And certainly the defendant fully agrees with the comments the Registrar made, that it would be extremely messy, be very, very messy to have a Part 7 claim and a Part 8 claim. It would be a waste of time and cost, and it would not be beneficial to either party. 21.7, of course, also says that the defendant may make a counterclaim against the claimant by filing particulars of claim. But it's quite clear the defendant's position is that it fundamentally disagrees with this claim being in Part 8. It should never have been brought in Part 8. It doesn't lend itself to Part 8. And I'm afraid the reality is that there are significant issues of fact in dispute between the parties, and this should never have been brought in Part 8 in the first place. It's a classic Part 7 claim. And as regards the submissions that the claimant has made in relation to somehow trying to present this as a simple enforcement claim, the defendant fundamentally disagrees with that. That's entirely a mischaracterization. And on the documents that have been filed in the hearing bundle, on the claimant's own documents, it's clear that there is a substantial dispute on the facts between the parties. The claimant is simply not correct in saying that there is no dispute of fact, and the claimant is also incorrect in saying that the disputed facts relate only to a potential counterclaim and that they do not touch or concern the subject matter of the claim. On the contrary, it's quite clear that the disputed facts do directly touch and concern the subject matter of the claim, and therefore the Part 8 procedure is not suitable and should not be used. We can see that the claimant's claim is primarily based on Interim Payment Certificate 31, Statement of Completion, and this is in the bundle at page 131. And this is in the bundle at page 131. This is a letter from the engineer dated the 23rd of July to the defendant Ellington with the subject Interim Payment Certificate 31, Statement of Completion. And this then encloses the Interim Bill 31, Statement of Completion, for an amount of 3.3 million dirhams. Now, this amount of 3.3 million, this is the amount that the claimant is claiming in these proceedings. And that's clear from the particulars of claim that this 3.3 million is being claimed. That's page 12 of the particulars of claim. And it's also clear that the claimant is primarily relying on this interim payment certificate 31. This is what is being relied on by the claimant. And that's also clear from pages 20 and 21 of the bundle. And what's important to note is this is an interim final payment. This is an interim payment certificate. It's interim, not final. And it's very important to note that no final statement of account has been issued. There has been no final payment certificate issued. There has been no defects liability certificate issued either. And it's quite clear that the final payment certificate must give credit to the defendant for all sums that are owed to the defendant that the defendant is entitled to. So what's quite clear is that the defendant is bringing this, what's quite clear is the claimant is bringing this claim in reliance on an interim payment certificate, not a final payment certificate. There are a lot of issues in dispute between the parties, and the final payment certificate has not yet been issued, and there has been no final statement of account. And in relation to the interim payment certificate at page 131 of the bundle, the last line specifically states, "We have not considered any amount Ellington Properties Development directly paid to the subcontractor in this payment certificate." So this is the engineer specifically admitting that any amount owed to the defendant, Ellington, in relation to subcontractor payments has not been considered by the engineer and has not been taken into account in the interim payment certificate. So that's the engineer himself making that quite clear. If we look at page 166 of the bundle, this is a letter from the defendant, Ellington, to the claimant regarding the payments to subcontractors. And this letter states that while the works of the project were proceeding, you, the claimant, were not able to make proportionate payments to subcontractors of the project, and accordingly you requested us, that's the defendant, to make direct payments to subcontractors for their entitlements based on certifications by the engineer. And it then goes on to say, in order to overcome the slowdown of the site works, the defendant accepted your request and agreed to make direct payments to all subcontractors identified by you and engaged in the project. It then says, we shall be making payments directly to the subcontractors whose names are listed in the table enclosed. And it goes on to say, at the bottom of the page, any amounts paid to the subcontractors by us shall be proportionately deducted from your payment entitlements or certifications. And the letter goes on to say that this letter is without prejudice. It goes on to say at the end, you as the main contractor shall fully indemnify us and hold harmless for the works done till date towards the project, and shall or procure to rectify, repair and remedy any delay or defect caused by you or the subcontractor. This letter is issued without prejudice for any of the rights as per the LOA, agreed construction contract or applicable laws. So it's absolutely clear from this letter that the claimant REEM asked the defendant Ellington to make payments to the subcontractor in its place, and such payments, it was agreed, shall be deducted from the claimant's payment entitlements or certifications. However, what happened is that the claimant then denied this, and the claimant tried to shift responsibility onto the defendant. And if we have a look at page 174 of the bundle, page 174 of the bundle, this is an email from Miss...
1 second. I should state the record that the bundle is not legible. I can't read anything. The script is quite blurred. So I will go on face value with what Mr. Page says. If there's anything that incorrect, then I would expect Mr. Smith to say something. Thank you.
Thank you, Registrar. I am actually largely just quoting from the correspondence, which I will continue to do. So, at page 174 of the bundle, this is an email from Mr. Yates of of Ellington, the defendant, to REEM, the claimant. And this is saying in this email, we are also stunned at your letter, stunned. Our payments to the subcontractors were necessary because RCC, that's REEM, the claimant, were not making the required payments, despite receiving payment from Ellington, claimant. Goes on to say, warranties and system training is a requirement of the contract. RCC, REEM, were supposed to pay the subcontractors. Ellington, the defendant, stepped in to assist REEM's default. Please don't try to shift blame your contractual default to Ellington. So it says, please don't try to shift the blame for your contractual default to Ellington, the defendant. This shows that there is a clear dispute on the facts between the parties over what was agreed, over who is in breach of their obligations under the contract, and which party is responsible for the subcontractor payments. And this dispute between the parties is then confirmed in the claimant's own letter of the 1st of October 2020, and this is at page 171 of the bundle, page 171 of the bundle. This is a notice of dispute from the claimant to the defendant, dated the 1st of October 2020, and at the second paragraph, point 2, the claimant says, unfortunately, the employer insisted to squeeze the facts, and place the blame over us for the payment of subcontractors' delay, while it was a direct result of his failure to release our due payments on time. The claimant then says, the above schedule may clarify the employer material breach of contract relevant to timely payments. We would like to refer you to our numerous letters recorded your significant delay in releasing our due payments. So it's clear that based on the correspondence between the parties and the claimant's own letters, it's clear that there is a significant dispute on the facts between the parties, and that this directly impacts the amount that the claimant is claiming on the interim payment certificate 31 in this case. It will be recalled at page 131 of the bundle that interim payment certificate 31 specifically states at the end, the engineer states, we have not considered any amount Ellington Properties Development directly paid to the subcontractor supplier in this payment certificate. So there is a clear dispute between the parties, and this directly impacts on the claimant's claim. So we absolutely disagree with the claimant's submissions that amounts have been admitted. We directly disagree with the claimant's submissions that this is a simple case. It's clearly not simple. There are very complex issues. And it's important to note that we are not talking about the small amount that was paid to subcontractors. At page 162 of the bundle, this is an email from Mr. Yates Ellington, the defendant, stating, number one, we are still awaiting warranties. Number two, we have paid over 11 million dirhams to subcontractors, which needs to be reconciled. Over 11 million dirhams to subcontractors, which needs to be reconciled. This amount is well in excess of the 3.3 million dirhams being claimed by the claimant, entirely wipes out the claimant's claim. So again, what this shows, all shows that there is a big dispute over the claimant's reliance on interim payment certificate 31 statement of completion. And there's a big dispute over what the claimant is entitled to, if anything, And not only is there a dispute over the failure to take into account payments to subcontractors, there is also a dispute over delays caused by the claimant and the fact that the defendant is entitled to liquidated damages for delay. And this is clear from the correspondence between the parties. If we look at page 183 of the bundle, page 183, this is a letter dated the 10th of December from the defendant, Ellington, to the engineer. And it states, this is the defendant stating, this letter is issued to you in order to apprise that the statement of completion, that's interim payment certificate 31, is not correctly valued. Is not correctly valued as it fails to account for the delays caused to the project by the contractor, for which the employer is entitled to claim liquidated damages in accordance with clause 7 of the letter of award. Hence, we hereby issue this letter to identify the delay and to revise the statement of completion accordingly. The letter goes on to say that we place on record that the project was substantially completed on 17th December 2019 at the issuance of the taking over certificate, causing delays of 477 days. It says thus, the employer is entitled to deduct delay damages in the form of liquidated damages due to delays caused by the contractor up to a maximum limit of 10% of the contract price, 5,162,607 dirhams from the amounts due to the contractor. On the next page, at page 184 of the bundle, this is then confirmed by the engineer in the engineer's letter, 18th of December, to Ellington, the defendant. This letter says in the bottom half, considering the above referred letter as your formal intention to proceed with liquidated damages, we hereby provide the calculations as noted below. Commencement date 27 February 2017, time for completion 18 months, date of completion 27th of August 2018, date of completion as per taking over certificate is 17th of December 2019. It then says delays in days, 477 days, which is in agreement with the defendant. Contract price, 51,626,000. Liquidated damages, 30,000 dirhams per day. Maximum liquidated damages, 10%. 10% of the contract price being 5,162,000 dirhams. And importantly, this letter says at the end, since the liquidated damages calculated per day exceeds the maximum limit, the maximum liquidated damages that can be applied shall be 5,162,607.38 dirhams. Hence, the employer may deduct this amount from the monies due to the contractor. The engineer specifically states the employer may deduct this amount from the monies due to the contractor. So again, what this all shows is that there are substantial disputes of fact between the parties, and there are disputes over any amount the claimant is entitled to under interim payment certificate 31, and over the amounts that the defendant is entitled to. All of this will require witness of fact evidence over the issues in dispute, as well as expert evidence on the issues of delay and quantum. So in conclusion, it's clear that this dispute between the parties is not at all suited to Part 8. It does not meet the requirements of Part 8, and it should never have been brought on Part 8 in the first place. Rather, this claim should proceed under Part 7.
Thank you, Paige. Mr. Smith, have you got anything to say in response?
Just a couple of things, and if I can just take you to that page 184, I took you to that before, Registrar, because Mr. Page took you to the bottom half of the letter and rather conveniently ignored the first half, which says that the payment certificate, the engineer says in no uncertain terms that we refute your allegations that the statement of completion, which is the IPC, the certificate number 31, is not correctly valued. So insofar as the claimant's case is concerned, we would say that only goes to support our claim that it is a certificate, and as Mr. Page said, it's an interim payment certificate. Now, I want to just dwell on that point for a minute, because the gravamen of Mr. Page's submission appears to be that a contractor has no ability to enforce an interim payment certificate, because if it means that the contractor has to go under Part 7 and the lengthy process that entails in order to effectively enforce its right to payment under the contract, rather than simply going under Part 8, which it has proceeded to do in this case, it means that it effectively is left without a remedy, because ultimately, in this case, what you've seen is that there's a certificate, and you were taken to the certificate previously, and I appreciate that you couldn't see it. But the other thing that covering letter on the certificate made clear at page 131 is that it is interim, and that the engineer has actually deducted an amount of 200,000 dirhams. It's been withheld against defective and outstanding work, such as hot water issues, swimming pool leakage, BMS works, warranties, etc. Precisely the things that Mr. Page now says is an issue between the parties. Now, this is an interim payment certificate, and our client was entitled to be paid this over 4 months ago. If this proceeds by way of Part 7, our client's not going to see this probably for another 12 months henceforth, which effectively renders nugatory the remedies available to it under the contract. So we'd say, as a matter of effectively a matter of fairness and justice between the parties, the more proportionate road is the road that ought to be followed here. In relation to the specific allegations, though, that were made in relation to subcontractor payments in dispute, we'd say that's just not relevant to the claim that's been brought. The reality is that the certificate has been issued. There's nothing in the contract that permits these certificates to be opened up. And yes, they are interim certificates, and yes, the claimant is entitled to be paid them, and all it's seeking is to be paid for the work that was certified. The defendant is in the building and is enjoying the building and has had the beneficial use of it for a very long period, yet the claimant remains unpaid. So what we'd say is that any of those other matters that might be in dispute are the subject of an entirely separate claim. If there is a big construction dispute to be had, then the defendant is well entitled to bring that if it sees fit. But what we're seeking is the enforcement of this interim payment claim, which, as I said before, and it's evident on the papers, it's been certified once, it's been certified twice, they had a third go, the engineer said, nope, we got it right the first time. And now what's been brought is the hint of a counterclaim to try to now stop this court from proceeding quickly to determine the claim, pay the claimant for the work done, and then to move forward. So we'd say, particularly in relation to the selective sort of rendering of the correspondence on the subcontractors, that's just not relevant to what's in front of the court for this dispute. And we think that it would be an abusive process to permit a counterclaim like that to be aired now, where what you've got, as Mr. Page rightly points out, is an interim payment claim. It's, as I said before, it's been considered numerous times by the engineer and the claimant, and the claimant has a clear entitlement to it.
Thanks, Mr. Smith. I do hear what you're saying, but using a very simple analogy, if someone was to purchase something online, they pay for it in advance and then they expect that whatever it is that they ordered would be delivered to their home. And in fact, it's not delivered. It's a pretty unfortunate situation because they might have forked over a substantial amount of money in exchange for the goods, which they haven't received. And then they have to go through the headache of trying to claim back their money through a contentious process, which is not ideal. It's not convenient, and it's the last thing that it's probably accepted. And in their minds, it's a simple enforcement claim. I paid you, you have to send goods, and you never did. The other side might say, though, well, I haven't actually received the money from you, that's why I never sent you the goods. And this is a very, very simple analogy, but nothing kind of legally in principle that says that the person who put their money forward is automatically entitled to a refund that they've paid without having looked at the facts to see if the money had actually received the merchant or not. And I think this is, again, a very, very simple analogy, but I think what we're trying to say, and I did make the point, this is akin to an arbitral award where it's a simple recognition and enforcement. But I don't think it is. I think it's an unfortunate situation. Your client has said, this is money you owe to me. And you have to pay it. There's no two ways about it. But the other side is saying, actually, we've forked over 11. And I know I've heard you when you set off that. So I do agree that it's a relatively complex case, not straightforward. And I am inclined to make an order to have it transferred to a Part 7 claim. And in the event, but before we do that, I would probably order that the defendant has to bring a counterclaim and that the case be transferred to a Part 7 claim. And the party, either the claimant or the defendant, are at liberty to make an application to transfer it to the TCD. Now, this is not to say that the claimant doesn't have the remedies available to it in Part 25 of the IDP. Not to say that the claimant apply to seek truncated procedural deadlines for things. That's one other way around how all of this works. But that will go to another hearing on why the defendant might have more time to submit further documents, etc. So that's something that can be visited down the track. But at this stage, I will make the order that the case is to be, first of all, that the defendant has to leave of court to bring a counterclaim, then that the case can be transferred to a Part 7 case, or has to be transferred to Part 7. And then thirdly, given the pleadings that have been exchanged, I think there might need to be, or parties would have court's leave to amend their pleading. So to that effect, the parties are encouraged to try and agree on a timeline for amended pleading. And I would suggest that the date by which they would try to agree the procedural timeline for the exchange of amended pleadings is Monday, the 8th of February. And in the event the parties can't agree the procedural time for the exchange of amended pleadings, then perhaps it can be a short deal with it, or I can deal with it on the papers and set some timelines. And the claimant or the defendant are at liberty to make an application for the case of the TCD. Cases in the TCD tend to flow a little bit faster than the CFI for various reasons. First of all, obviously, you've got the obvious reason that a lot of time construction can be delayed when there is a claim being made by one of the parties. So we don't want to any further. Sometimes we do tend to flow cases through PCG a little bit faster. And then, as I said, the claimant is at liberty to make an application for truncated timelines, procedural timelines, and that be agreed with the defendant. And my last order would be the case, and cost of this hearing being the case, rather.
I apologise, Registrar. I missed the last thing you said about costs.
I beg your pardon?
I missed what you said about costs. Sorry, turn up.
The cost simply in the case, Mr. Smith. I think costs will be delayed till the end, so cost in the case.
No. Thank you, Registrar.
Thank you. Can I ask Mr. Page and Mr. Smith to agree the wording of the draft order that I've just handed down and that's sent to the court? We'll fill that as soon as possible.
I think that I picked up most of the points that you mentioned there, Registrar, but the line unfortunately was breaking up quite a lot.
Not a problem.
I don't know whether it's possible to... Sorry.
Sorry, Mr. Page. Would you repeat it? Would you prefer that the court decide the wording of the order?
Perhaps if the court could do the initial wording so that there's been no misunderstanding over the line of the order. Perhaps if the court can either send it in writing what's been decided, either in an email or in a draft, to then seek to agree if possible.
Not a problem. The court will do that. Is there anything else?
And not from the defendant, thank you.
And not from the claim at this stage either.
Thank you very much, Mr. Smith. Mr. Page, have a nice day.
Thank you, Registrar.
Thanks very much.
Thank you. Bye-bye.
Thank you. Bye-bye.